Welcome everybody to another episode of Tax Sale Insiders. I have with me today a veteran, contributor, Matt Abee with Nelson Mullins, and with him, Jonah. I think you've been on the show as well. Jonah Samples, also with Nelson Mullins, and well, I don't want to steal all your guys' thunder. We talked about the Tyler Hennepin case multiple episodes, and I think everybody in this space was like, okay, that was some excitement. We haven't had that, okay, another 20-year cycle before we have that level of excitement. And not to throw you under the bus, man, but a little bit, you put it out there in the universe. I think at NTLA event a while back, and lo and behold, we have a new case that the Supreme Court has decided to take up. But well, let's again, I don't want to steal all of it, but let's get us up to speed. What's going on, or what's the case, and kind of set the table, Matt.
Yeah, so we thought that the Supreme Court was done with the boring world of tax liens and tax deeds, and looks like we were wrong. So of course, Tyler versus Hennepin County was an opinion came out from the Supreme Court that really changed the way that some states were looking at the tax foreclosure process. Held that Minnesota's statute was unconstitutional, an unconstitutional taking, which has sent some reverberations throughout the industry in other states. And the most recent development there is that the United States Supreme Court has decided to take up another tax sale case, not from Minnesota this time, but from Michigan. And this is a case called Pung versus Isabella County, which involves, we'll get into the facts a little bit here in a second, but essentially it's asking whether or not looking at the valuation of the surplus proceeds, and how are you supposed to figure out how much a homeowner is owed. And then it's also looking at a question that was left expressly open by Tyler, which is, can the disparity between the taxes owed and the amount that the property is ultimately sold for, can that create some sort of excessive fine under the Eighth Amendment? So it's one that comes out of Michigan, but it's going to have some implications, I think, around the country. So hopefully we can chat about it a little bit today and inform some of your listeners about, what does this mean for them in all different states?
Yeah, and I think this is probably oversimplification, but Tyler Hennepin, essentially the Supreme Court said, hey, there's some states where the previous owners are getting nothing, right, do these foreclosures, and that's not constitutional, right? And they left a lot of unanswered questions, which are being hammered out. They intentionally left them unanswered to be hammered out at the state level, and there's some states that haven't hammered that out yet. I think that's kind of the wild part. But and then now we've got this one, which is maybe intended to answer some of those questions, but definitely a follow-up. But Jonah, you're the expert as far as Michigan goes, which is where this case originated. Can you get us up to speed on kind of the facts of how this all began? I know there's a lot of legislative changes in Michigan, and how did we get to where we're at today?
Sure, absolutely. And, great to be back. This is my second time here. So, it's not my first rodeo, but I guess by your second rodeo, they assume you know everything. So here we go. But yeah, second rodeo. So yeah, Michigan. So pre-2020 is what kind of we want to start and focus on. And that's actually what is most relevant for the Supreme Court case that, Pung, that we're talking about here today. But part of it is understanding kind of how Michigan got here, because it's kind of been at the center of a lot of the debate that we've got going on. So Michigan has the General Property Tax Act. And so pre-2020, counties could foreclose, sell at auction, and keep the entire sale price even when it exceeded the tax debt. And so there's no statutory mechanism for former owners to reclaim the surplus. This was not entirely unusual, but was one of the stricter states at that time. And this is, obviously local governments rely heavily on these proceeds. This is something that, that's why this is set up this way. Now, and then when you transition into 2020, there was both a legislative change and some judicial case law that came down that prompted that legislative change that led to, and you're going to see that as we go through kind of the Michigan history, is that there would be a judicial decision and then there'd be a corresponding legislative change. And that's kind of how we got to the point that we are here in 2025. And so the first case was in 2020. It's called Rafaeli. And so the Michigan Supreme Court held in that case that retaining the surplus proceeds violated the state takings clause, which is important. This wasn't a interpretation of the federal constitution. This was specifically a Michigan constitutional issue. And so the facts there's an $8.41 underpayment, which resulted in $24,000 in retained equity. And it was found that the former owners have a property interest in the process, in the surplus proceeds. It was limited to state law, and it did not address federal claims at all or retroactivity in that case. And so in response, the Michigan legislature amended the GPTA to create a surplus claim process moving forward, but there wasn't really a retroactive relief component from that statutory change or from the judicial decision. So even though Rafaeli established that right under Michigan law, it didn't settle the federal constitutional question. And then we get to Tyler. Obviously, I mean, we've talked about Tyler ad nauseum. I mean, I know Matt's been on here, talked about it. I've been on here and talked about it, and everybody in the industry is kind of aware of what happened there. But that all happened in May of 2023. And then after Tyler, there was, there's this Freed case. And so the litigation shifted from whether or not is this a taking to like, what is the remedy, right? So then the Sixth Circuit, obviously this was a federal case. The Sixth Circuit found that just compensation equals the surplus proceeds, so the auction price minus tax debt, not the fair market value. And then this protects the reliance interest and avoids the destabilizing titles. So Tyler answered the if, Freed started kind of answering more of the how much. And then this set the federal remedial baseline in Michigan and in some of the neighboring states. And so that brings us to kind of an important case. It's less flashy, but it was Fox v. 27 Michigan counties. And then this shows why the how much question matters beyond just a single plaintiff. So this case was actually a class action, and it was brought on behalf of property owners across 27 counties, right? Because that's who the parties were. So the plaintiffs argued that the injury was uniform and class treatment was appropriate. And then the defendants argued that the valuation should be individualized, right? So then the Sixth Circuit rejected the class certification, holding that the surplus-based remedy requires property by property calculation. So it's individualized. You can't handle these on a class basis. These are individual plaintiffs with individual constitutional rights. It rejected the broad jurisdictional link tying all the counties together. And then why this one matters when we're talking about all these cases and statutory change, it's that the remedy definition directly impacts whether these cases proceed as a class or individual suits. So there's supposed to be individual suits under this ruling. And then also there's big implications for the counties, the investors, and just general litigation strategy and how these are handled, because it's based on the individual facts for the plaintiff, right? And so while that's happening, the Michigan legislature is responding to Rafaeli in the aftermath, but it didn't really close the gap on all the federal questions. So in response to Rafaeli, somewhat Freed, somewhat Fox, the GPTA amendments created structured claims and notice requirements, but there wasn't necessarily a retroactive compensation. There's no federal valuation standard. Obviously, these are state statutory changes. And then a lot of the litigation gaps kind of remained. And then these unresolved issues set the stage for the case that we have here today, right? So that's the Pung case. And so I'll kind of pause there. But when you're thinking about Michigan as a state, it started out with, all the surpluses would just be absorbed by the counties. And then now it's like, as these cases have come down, you've seen kind of the statutory change kind of develop. And this has kind of been a pretty big battleground where we're talking about the entire process.
A lot going on. So I think maybe one of the primary questions that, listeners are probably wondering is, so what is the potential? I mean, it's a Michigan case, right? And so what are the potential ramifications? Are there any outside of Michigan? And Michigan, I think, is, at least how we define it, is a tax deed state. And so are tax lien investors affected by this? Maybe Matt, maybe both of you can share your 2 cents, but Matt, what are the potential ramifications of this?
Well, so Michigan has in some ways been the tip of the spear on this issue, in the sense that, as Jonah was explaining, that this whole takings issue was born out of Rafaeli and out of state law, and it was developed in Michigan based on state law. And then next thing you know, we turn to the U.S. Supreme Court and we see the U.S. Supreme Court deciding it as a matter of federal law. So obviously those two sources of law are different, but they can complement each other in many ways. And so Michigan was somewhat like the testing ground for, they had this decision early. So the legislature had to react to it and try to fix it. And anytime a legislature gets involved in a developing issue like that, they'll impose some sort of change, but they don't always get it right, or they might leave some holes somewhere, or there might be just some intentional vagueness that's built in because the legislature might want to see how the law develops. And so that's happening 50 times over, right? I mean, any state that has a takings issue then starts to develop a legislative change in response to it, or a judicial change in response to it. And so you just start seeing all these different solutions that are around the country. So although this case that we're going to talk about is Michigan centric, in many ways, any kind of other statutory scheme in any other state that involves a generation of a surplus from the sale of the property could have some of the same components as the Michigan statutory scheme, and could involve some of the same legislative changes in response, maybe not to a state court decision like Rafaeli in Michigan, but in response to Tyler. A number of legislatures jumped in and started making changes. So it's kind of it's almost a microcosm for a larger issue across the United States. And so that's where this particular case comes in, because it is trying to fill in the gaps of the issues that were left by the Tyler case, such as Tyler just decided that a taking had occurred under federal law, but it didn't decide questions of how are we supposed to value that taking. It didn't decide who should pay that amount, and really what the mechanism would be for going back and claiming it. And so that's where this Pung case steps in, because it tries to decide those issues, and of course decided it adverse to the delinquent taxpayer. And so that's where they continue up the chain, and they convince the United States Supreme Court to take the case.
Yeah, so it's and I think if I remember right, Jonah, you probably mentioned the case. I just don't remember the case, but there were two cases at the Supreme Court to be reviewed, right? And they just happened to pick Tyler Hennepin, but there was a Michigan one that was sitting on their desk, and they basically said, "Nah, we'll take this one," right? But Michigan, as you stated, has maybe been the source at some level, right, of both what culminated in the Tyler Hennepin and obviously this new one.
The other two cases, but there were two that were in the background of Tyler. Those were both out of Nebraska. Michigan has had a number of different cases. One that Jonah mentioned is that Freed versus Thomas case. And the petitioner there did try to take that up to the Supreme Court, but the Supreme Court didn't accept the case at that time.
Okay.
And that, by the way, that's not unusual for the United States Supreme Court. They like cases or issues to what they call percolate, meaning that if they decide an issue, they like the lower courts to wrestle with the unanswered questions a little bit, because you got multiple courts around the country, multiple different jurists that are looking at it, and that kind of helps the case law develop and mature, if you will, so that by the time it is up to the United States Supreme Court, you've got a bigger body of case law. More people have written about it, more people have sat and thought about it, and it just helps to develop the law from a nationwide standpoint. And so not unusual that the court would not address this issue in the Freed case and wait until this case came up. That's just kind of that's the percolation process.
Got it. No, I don't necessarily want to be the bad news bears, right? I think one thing that we all know is that things don't necessarily go logically, right? And there's some questions, then depending on how those questions are answered, could have very negative effects on the, say, both tax lien and tax deed sales. Is it possible to just summarize what a worst case scenario could be coming out of this, Matt or Jonah?
Yeah. So one thing to think about is that the law that the United States Supreme Court is trying to develop when they issue an opinion, they're trying to develop something that has nationwide implications, right? They're not trying to just decide individualized cases for individual people companies or governments. It's more of a nationwide scope, right? But that doesn't mean that the facts of a particular case don't matter. Obviously, the facts are going to drive the way that the law develops, and sometimes when you have some bad facts, you can have bad law that comes out of it. And that's why I think first let's look at the facts of this particular case, because that'll set the stage maybe for where the court could go and what are the different options, what are the different arguments, that kind of thing. I think it's important to look at specifically what happened with Mr. Pung and with this particular tax sale.
Yeah, and so it's kind of transitioning from that. I mean, so what happened is, so Timothy Pung purchased this property in 1991 for about $125,000. And so after his death, it passed to his nephew and retained its principal residence exemption. So that's the PRE exemption until an administrative error actually removed it. And that error caused the property to be taxed at a higher than, your non-homestead rate, creating a delinquency of about $2,200. And so it's important because that was determined to be improper. So like Matt's saying, like these are not excellent facts, because there's a $2,200, unpaid tax that was found to be improperly assessed in the first place. And so the county foreclosed after the redemption period expired and sold the property at a public auction in September of 2016. The sale price was about $76,000 and the assessed value was around $194,000. And so the buyer resold the property shortly after for close to the fair market value. And then the county retained the entire $76,000 in change in proceeds. And so kind of to Matt's point, these are like I said, these are not excellent facts. The other thing, and when we're talking about kind of the broad implications, this is under the old statute. So, I mean, the sale was in 2016, the delinquent taxes from 2011-ish. And so when the court's taking a look at this, it's not even necessarily addressing the current statutory scheme of Michigan, because this is not the statutory scheme of Michigan. This has changed. And so now the Supreme Court is going to specifically address these issues, not kind of, toss it over to Matt or Brian if you have any questions. But I mean, Matt, you can kind of talk about like what the questions that the court has specifically been asked to address in response to this petition.
Yeah, and so they're asked to look at this old statutory scheme and figure out if that difference between the $2,200 roughly in taxes that may or may not have been owed and what the county sold the property for at the auction, $76,000. The court's really looking at is the surplus that the takings would apply to, the takings clause would apply to, is it that $74,000, or do we need to really look at the fair market value on an open, perfect market of roughly $194,000? We deduct that $2,200 in taxes, and then we got $192,000 in excess that maybe is due to the petitioner. And that's where what I was saying earlier about the factual background is going to have some play in this, because it's just so weird to think about a case where someone loses their property for taxes that may or may not have been due, because maybe the Pung family was entitled to this principal residence exception, and because of some procedural issues, they didn't get it. What actually happened is Mr. Pung missed some statutory deadlines to go back and apply for the exemption, then to appeal it. And then that ultimately ended in a foreclosure judgment that he couldn't challenge. So he's not, he had some blame in this. I don't want to suggest that it's just, a bad government coming in and trying to take some guy's property. But that's going to have an impact on the decision, because that's going to color people's view of what the ultimate remedy should be here. But on the valuation question, which is the first question that the court agreed, we're trying to figure out what do you mean by fair market value when you are looking at a forced sale, a government sale of the property. And as your listeners know, when you go to a tax sale, you're not expecting to pay the full market value of the property. And the reason for that is a number of reasons. You don't get to go in and do a home inspection. You may or may not be able to do a title inspection. You're not doing an arm's length transaction where you are going in and buying the property with eyes wide open, knowing all of the problems with it. You are trying to get the most information that you can about this property and make an educated guess. And so not just tax sales, but really any kind of forced government sale or foreclosure, sheriff's sale, you're going to have most likely a valuation that's a little bit lower than fair market value. A lot of different reasons for that, and a lot of different factors will come into play. But what courts have said in other contexts is specifically a case that is referred to in the Pung decision from the Sixth Circuit, which is BFP, 1994 U.S. Supreme Court case, which talked about that the fair market value when you've got a distressed sale or a forced government sale is the value that the property fetches at the auction, right? Because that's the best indicator of value, because you have people showing up, they're putting their paddle up and saying, I'm willing to pay this. And you've got to take into account the circumstances under which the property is sold. And that doesn't allow you then to say, well, you don't get to go Monday morning quarterback and say, well, it should have been sold for this much. You should have marketed it differently. You should have XYZ, right? And so if the court relies on this prior BFP case, well, then it's going to say that the fair market value for the takings analysis is the value that it fetched at the auction. And that would seem to be a reasonable decision. So applying that to Mr. Pung's case, then he would be entitled to roughly $72,000 in surplus proceeds from the county, rather than his $192,000. But what Mr. Pung's going to say, and what he said in his petition, is that the Constitution requires fair market value, and distressed sale is not a fair market value. So therefore, we've got to impose this kind of nationwide requirement on every single tax collector and judge that's reviewing these, and tax assessor and investor, really anybody who has a stake in the process of tax lien or tax deed foreclosures. We have to make them actually do a valuation analysis. We have to make them actually look and see what is the fair market value. And if it doesn't sell for that, well, then we need to just void the sale, and tough luck, we'll go sell it again. And that argument, there's a number of different shortcomings with it, but one of the problems is the trying to make everybody valuation expert when they're not valuation experts is problematic, because what I think is that the better evidence of what something's worth is what somebody's willing to pay for it. And when you got an open auction where you've advertised it, everybody knows about it, it's not some backroom deal, but it's actually done in public, then that's a good indication of the value. And so that's the first question that the Supreme Court's going to wrestle with in this case.
Yes, and that's obviously a big question, because even say mortgage foreclosures, and I'm not an expert in every state, but even then the opening bid is not appraised value or assessed value. It's usually a percentage of that, right? And then I think the mortgage holder has the right to have a minimum of whatever their current balance is, right? And so stating that it has to be full market value obviously blows up more than just tax sales. It has ramifications outside of the space into these other industries and foreclosure actions as well, which I think we all like to think that what makes sense is what we'll decided, but we don't know that for sure, right? And that's the scary component of it. So are there any other questions that they're agreeing to at least help answer in this, Matt?
Yeah, so the Supreme Court's also going to look at the Eighth Amendment excessive fines claim. So Mr. Pung also had a claim which was very similar to what was raised in Tyler, that he shouldn't be penalized by losing $194,000 property because he forgot to pay or failed to pay $2,200 in back taxes. That is excessive. It's akin to cruel and unusual punishment. so an excessive fines. Now, the Supreme Court didn't address that argument in the Tyler case. And what the court said is the takings order or opinion, the ruling that we gave on that issue, it was dispositive, so we don't need to touch this other issue. And that's standard for the Supreme Court to do, because they usually want to decide cases on the most narrow grounds, what really matters to the decision. But there were two justices led by Justice Gorsuch who said, well, maybe we should really relook at this because in the past we have said that the Eighth Amendment doesn't really apply in the civil context, meaning it doesn't apply to like business transactions, monetary issues. It just applies in the criminal context. And the court has expanded that a little to say, well, it can apply in the criminal context, but when there's an asset forfeiture as a part of a criminal case, then excessive fines clause can apply there. And so Justice Gorsuch suggested that it could apply to taxes potentially if the purpose of the tax was to penalize for not paying the taxes, and if it was attempting to impose a fine because you didn't pay the tax, right? So the Sixth Circuit said no, it's not an excessive fine. It just doesn't fit within the Eighth Amendment case law that's out there, and that's something that the court could address here. The court could again punt on that issue. It could say that, well, if we satisfy the valuation part of this, well, then we don't have to touch the excessive fines. But it also could take a different approach, because really the difference between the two issues before the court is really a question of what's the right remedy. So on the first question about the takings, the right remedy is how much somebody must pay to compensate you for the taking that has occurred. On the excessive fines clause issue, it's not what you should be paid in order to offset the excessive fine. It is, if you imposed an excessive fine, well, maybe that shouldn't have been imposed at all, and we need to unwind the entire transaction. So the court could look at it that way, which could lead it to actually decide this question. And who knows what the court might do, whether they apply it in this civil remedial context rather than in just the criminal context. But that could open a Pandora's box, because you know there are a ton of people that hate taxes that are out there, right? And if you start giving them the Eighth Amendment as a way to start saying, well, everything's an excessive fine, you might get people coming out of the woodwork that start challenging, and it just opens the floodgates to litigation over exactly when does something become excessive.
Yeah, well, I think that's and they won't answer this, right? Let's say they do say it's excessive, but they won't answer.
Right.
Well, then what else? What do you do, right? I mean, that's the talk about Pandora's box of, oh, it's excessive, and then every state's going to be like, what do we do now, right? I think that's the
when does it tip over from just a fine to an excessive fine? And so you're right that the court doesn't always answer that next question. It didn't in Tyler, for example, when it said this is a taking, but we're not going to tell you how much of a taking it is or who has to pay for it. So, but that again goes back to what I was saying earlier about the law maturing and percolating through the lower courts. They kind of issue these broader decisions that allow the lower courts to then wrestle with them. But that uncertainty is what you just touched on is really what I think that the industry as a whole needs to be thinking about here, because what we want as attorneys going in and advising clients is we want some predictability, right? Jonah and I want to be able to tell a client, if you do X, Y is likely to happen. But when we're telling tax lien buyers and tax deed buyers right now, we don't necessarily know. When you go and bid at this auction and you buy it for X but then sell it for Y, we don't necessarily know, is that going to be the measure of damages? Do you need to hold some money back to be able to pay excess claims? There's just some uncertainty. In this case kind of adds fuel to that fire, and is something that we really could get some great guidance from the Supreme Court. They could say that the amount bid at the tax sale is the best evidence of the market value of that particular property. So that could be great. But the other side of that coin is, well, that in the run of the mill case, yes, that is the best market evidence of market value. But you can have cases built on bad facts where that might not be the scenario. And then you've got judges who are going and looking back at valuations and trying to figure out how to value these takings claims.
Yeah. So the ultimate worst case scenario, again, I think it's unlikely that this were to be a thing, but it's it's not only excessive, but it's, for those that have occurred, what the previous owner is due is assess value, right? And we put those two together. And is that even a scenario, or is it more of a, because if it's excessive, then is the value thing even I guess it's still kind of a question, but they're basically saying that foreclosure should have never happened, right? That's probably more scary. I don't think you wouldn't have hey, this is excessive and the value should be this, that those two answers don't quite go together. Do I understand that right, Matt?
Yeah, I mean, I think they're distinct, a distinct analysis for each one. But you do touch on something there, which is who really is going to be the one deciding that, right? I mean, who's going to be deciding these value questions, and what number is it? The tax assessed value that the assessor puts on it, or is it something that someone else a value that somebody else puts on it? So I have been focusing on this issue from the tax deed buyer and the tax lien buyer's standpoint, but I mean, it could, right, Jonah? I mean, it could affect other people,
right? Because to Matt's point, it's who has to come up with the fair market value, and then again, it's like, what is that even like? Let's say the tax assessor comes up with this is what the fair market value is, and then like instead of just like this is what the taxes are, the assessed value. Like now we have appraisals, and now I mean things are expanded. And I mean, in some states, even there are different statutory schemes for when you're talking about just property tax generally, like in West Virginia, where I sit, for example, there are specific ways that you value property that are different and separate from what an appraiser would do. And so then it's like, okay, well, which one is the fair market value? And then you have that debate as well. So it's really good. I mean, this could be a complicated question.
Yeah, if you want a summary of how many different opinions and value of properties, go to realtor.com, Zillow. Like every site has its own value, and it can vary $100,000, right, on the same property. So who's right? And I think that's back to what you mentioned earlier, Matt, of I can't remember the case, but it was, hey, if it's at auction, whoever's willing to pay a certain dollar amount, that establishes probably the most fair value. This is a wrinkle. I don't know if this is probably not something they'll even take into account, but we do see areas where properties are sold at above county assessed value, especially with vacant lots. And so what happens in those scenarios, right? Is do you only sell it like, well, is the previous owner only do what up to the market value? What is the remaining, right? I don't think the intent is to even open that Pandora's box as part of this case, but it certainly would open more questions of scenarios that aren't even really thought about.
Well, and what happens if the value, like the government official gets the value wrong, right? Or does the assessor then have to open up the pocketbook for the county to pay that? And we've seen in Nebraska, for example, the two cases you mentioned earlier that got remanded with Tyler, the Nebraska Supreme Court there said that investors could be liable for paying these excess claims because they were acting in concert essentially with the government actors. And so that argument can kind of run both ways, and you could have a scenario where both the taxing official and the bidder at the tax sale foreclosure are jointly liable for this amount. So if the tax assessor gets the valuation wrong and a court looks at it and says, well, no, that shouldn't have been the value, it should have been a higher market value, then can governments be on the hook to pay these amounts? We don't know the answer to that.
Well, they probably don't want to answer that as part of this. Will they? One answer leads to more questions. Peel back that onion, right?
Right.
Was there, I guess, any other facts based items that either of you want to run through, or I know this just got dropped, right? And there's kind of a timeline associated with the next steps. But before we dive into the what's next, any other closing thoughts from either of you?
No, I think it's just something that both the industry and government officials need to watch, because there are a lot of different implications for how the court might decide the valuation question, as well as the excessive fines question, because it can impact not only the statutory scheme and how you need to go through that process, but can impact what liability you might have on the back end if you're in any of those groups.
Yes, that is a good question. That's a great. And Jonah, anything else from your end?
No, I mean, just to reiterate Matt's point, I mean, this is something we're gonna have to watch and see and pay attention to. And so, yeah.
So on that front, I guess, what are next steps from here, Matt? What's the kind of next date that we're tracking, and do you have a timeline of what's supposed to happen when?
Yeah, so about mid-November, Mr. Pung and his attorneys will file a brief with the U.S. Supreme Court. Then mid-December, the county will file a response. I'm sure there'll be a number of different other entities that file friend of the court briefs to inform the court about how their decision might have some impact. And then Mr. Pung gets a chance to file a reply brief to have the last word for argument, which then tees this up potentially for oral argument sometime maybe March or April. It largely depends on what the court calendar looks like. And then traditionally, the U.S. Supreme Court will issue all its opinions by the end of the term. So think late June, early July is roughly when the opinion could come out. If it's like Tyler, can come out earlier, can come out in May. But generally, the court treats the end of its term as its deadline for issuing an opinion. So I think it'd be good, everybody keep an eye on the filings for sometime mid-November to see what Mr. Pung has to say. And then I expect that the county will have a pretty strong response given the issues that we're talking about here and the potential liability that Isabella County and counties all around the country could have.
I appreciate that. Matt, Jonah, immensely appreciate your guys' time. I'm sure if I can snag your guys' time again, we'll be talking about this topic several times over the next roughly year. But I appreciate again, and I guess everybody listening, hopefully this piqued your interest. Definitely stay in touch with our next episode. We'll keep an eye on this case as we move forward. And good luck, everybody.